Okay, then I will turn to the state for an argument. Mr. Lizet.
Thank you, Your Honor. As the court is aware, it is the state's burden at this juncture to demonstrate by the greater weight of credible evidence, so it is a relatively low burden, but it is the state's burden to demonstrate that Ms. Schabusiness is competent to proceed in this matter. I think when the court considers the totality of all the information before it, that it's quite clear that Ms. Schabusiness is in fact competent to proceed in this case. And this is a judicial decision. It's not a medical decision. It's a decision that the court can make based on a variety of different factors. We've now had 5 different competency evaluations in this case. Dr. Litton's evaluation is frankly the only evaluation that suggests that she's not competent. I think there are a number of flaws with Dr. Litton's evaluation, and I think that Dr. Seipel's report and his testimony here today call into question a number of her findings and certainly the methodology that was used today. And I do just want to take a moment that when I asked the question about Mr. Freilich being present, I certainly was not intending to suggest that Mr. Freilich did anything inappropriate at all. That was not the purpose of my question. I think to the extent that Dr. Litton had someone else in the room, that's a decision she made that may not be consistent with best practice, but I don't want to suggest that Mr. Freilich made any attempt to try to influence competency. I do think that what clearly makes the most sense is Dr. Seipel's ultimate conclusion in this case, which is that to the extent that there are any potential symptoms of psychosis in this case, that those symptoms had generally been driven by 2 things: intentional use of illicit substances, particularly methamphetamine, and then volitional conduct, frankly, on the part of Ms. Schabusiness. And of course, as the court is to consider, it isn't just does she have a mental illness, does she potentially have some sort of symptoms that may in some way make it more difficult or more challenging for her to participate. The issue is, do those symptoms, if they exist, do they substantially impact her ability to understand what's going on and to assist in her defense? And I think quite clearly neither of those things are present. Frankly, I'm not sure that even the motion from counsel suggests that there has been a significant impact in his ability to work with Ms. Schabusiness on this case as a result of any of those perceived symptoms. And in the interviews that she's had with all of the clinicians, she appears to generally understand the concepts, the legal concepts. She knows who her attorneys are, what the role is. She knows what the state's role is. She knows what the court's role is. She understands what she's facing, why she's here. And she is able to pretty substantially describe the facts that put her in this position. And the court is able to consider all of the facts and circumstances that are available and its own observations of the defendant at counsel table, of her ability to sit through lengthy, complex motion hearings without disruption, and apparently to assist her attorney throughout that process, and Mr. Freilich's ability to communicate with her quite well. It does appear that she and Mr. Freilich have developed a quality working relationship and that she's able to assist him in this process. I think when the court evaluates it has met the weight of credible evidence that Ms. Schabusiness is competent to proceed in this action.
Okay, thank you. Mr. Freilich.
Thank you, Your Honor. The law, Wisconsin law 971.14 subsection 3 of the Wisconsin statutes indicates that no person who lacks substantial mental capacity or understanding of the procedures to assist in her own defense may be tried, convicted, or sentenced for the commission of an offense so long as the incapacity endures. We have a young lady here, Taylor Denise Schabusiness, who does have mental health problems. She's been at Bellin Psychiatric Center for mental health treatment. They said that she had bipolar disorder with psychotic features. She's been to the Nicolay Psychiatric Center for a commitment, 6-month commitment order. She was there for about a month, but she was under a court order for commitment that was filed April 1st of 2021, and that she was deemed to be mentally ill. She was deemed by the court to be adjudicated as a mental defective or committed to a mental institution. She was at the mental health institution and that she was under a court order to take psychotropic medications. So she has a history here of lots of problems. The Brown County jail records bore out that she's had problems with following directions, standing for head count, drawing on the walls, doing all kinds of bizarre and odd behaviors. And what we have here are two diabolically opposed conclusions or opinions from the psychologist here. Dr. Seipel feels that Taylor Schabusiness is competent, and our doctor, Dr. Lighton, who has a lot of experience, she opines or concludes that she's not competent. So we have a problem here. We're at a crossroads. We've got some issues that have to be sorted out. I beg to differ with Dr. Seipel. I mean, he testified that this is not a complex case. It sure is a complex case. There's lots of records. There's lots of history here of mental health problems, drug addiction issues, all different kinds of problems. I think that both of the doctors have a lot of information, have a lot of training. They've looked at all these reports that have been submitted to the court. But Dr. Tracy Lucetta, who's also a PhD, she sent in a report that was filed on May 6th of 2022 when my predecessor, Attorney Jolly, was on the case. And she indicated that she recommended that my client be transferred to one of the state's psychiatric facilities like the Mendota Mental Health Institute or Winnebago Mental Health Institute for further evaluation under close and extended observation by qualified professionals. If she was sent to a state facility like that for a week or a month or whatever time is needed, a whole team of professionals could assess, fully assess my client's competency to proceed in this case. There are all kinds of issues here that have to be sorted out. It's not a clear-cut case, in our opinion, and I would argue that, a 90-minute interview by Dr. Seipel with Ms. Schabusiness, I don't think that is going to be able to be enough time to really fully understand and address the issues in this particular case. Dr. Seipel didn't do the MMPI or the MCMI. Dr. Lighton did not. Dr. Engine apparently did. I also want to comment on the issue with Dr. Lighton. She asked me to sit in, and I know that there were concerns because the chair was thrown at her, and she's an older lady, and so I sat in, and that's what happened there. I didn't get involved. I stayed out of it, but I was just there I think my client felt more comfortable with that, so I just want to comment on that. But I believe that my client is not a very good historian. I think she's got memory deficits. We've got all these records that I've poured over and looked at, sent to the court. I think that my client has had or does suffer from bipolar I disorder based on my review of the records. And, based on her conduct with regards to throwing a chair at the professional that's trying to evaluate her, attacking her, Mr. Jolly, allegedly previously in court, engaging in other courtroom antics, the staple going into her arm, not taking medications, who knows? Who knows if the drugs, the methamphetamine, the marijuana, the cocaine, all these other drugs, did they cause brain damage? Did they cause a mental defect? That's all for the court to decide, but I submit that it likely did. And it's caused a lot of different problems for Ms. Schabusiness with being able to really participate, understand what's going on, assist in her own defense. The fact that she apparently did have some hallucinations in the past, I think all that leads to the conclusion and my argument that my client should be deemed not competent at this time, or if the court doesn't feel it can even make a decision on that, send her over to Mendota or Winnebago for a further evaluation. Then we'll know. Then we'll know for sure if she's ready to participate in a trial and assist with defense counsel and be able to understand what's going on. I have some serious reservations on her mental status, especially in light of the civil commitment, especially in light of the order to take medications. She has been deemed mentally ill by a court of law, so nobody can dispute that. I would submit that that's likely continuing, but there's all kinds of different opinions here. So I'd ask that the court go along with my arguments that she be transferred to one of the state's facilities for further and extended observation. Thank you.
Thank you, Mr. Freilich. Well, I've had an opportunity now to listen to the testimony of both of the evaluators. I've also had an opportunity to review both of their reports. I've had an opportunity to observe and weigh their Ms. Schabusiness and how she's participated in this case. And on several occasions in the past when we've addressed this issue, I've had I've reviewed the history, and I'm not going to review the history of the competency process that's gone through here in this case again, because I've done it several times. But I want to highlight a few things, and that is that on 3 separate occasions this court has ordered, has tasked the Wisconsin Forensic Unit with assessing Ms. Schabusiness' competency. And I know there's been other evaluations that have been conducted as well, but in the first one, Dr. Collins really cautioned the court to maintain vigilance on this issue throughout the case, and I have done that. I have done that, and I've listened to the requests for, on various occasions, to have more competency evaluations conducted. On a few of those occasions, I've denied that request, and then this time I granted it because Dr. Lighton came forward. Really, each of these evaluators has a different opinion. Dr. Lighton's opinion on page 2 of her report is, quote, "My opinion also is that to a reasonable degree of psychological certainty, Ms. Schabusiness is not competent to proceed to trial," close quote. Dr. Seipel, as he testified here today, has an opinion directly to the contrary. His report indicates, quote, "The weight of the credible information again points to the conclusion that Ms. Schabusiness is competent to proceed, and I offer that opinion to a reasonable degree of professional certainty to the courts for the court's adjudication," close quote. In analyzing not only their testimony but the reports, I parsed through the reports, and frankly, it's actually difficult to parse out and unwrap Dr. Lighton's report regarding which piece relates to the NGI and which piece relates to the competency. Some things I want to just address regarding Dr. Seipel's report that I find meaningful, that I find insightful to me. I'm going to read a couple of those things. On page 14 of a report, he addresses his interaction with Ms. Schabusiness, and I think it's very relevant. He says, quote, "Her commentary occasionally waxed somewhat provocative, for example, sexual or otherwise graphic. However, such comments were not directed at me in any form of threatening or solicitous manner. Rather, she simply seemed to be fishing for a reaction. Thus, I either ignored such comments or matter-of-factly acknowledged them before continuing with my line of questioning. Through such an approach, I was easily able to sustain Ms. Schabusiness in rational, reciprocal, forward-moving discussion. Her replies were almost always relevant, albeit not always forthright, and she was easily redirected and responsive to prompting when needed. Moreover, in the few moments Where she was evidently confused by questions, she easily benefited from simple accommodations such as repetition and rephrasing. Her expressed thoughts were consistently organized. I detected no credible delusional beliefs, finding claims such as that she believed Dr. Lighton to have stuck her tongue out had her to be entirely lacking in credence. I found that relevant. It was a direct reflection of what the doctor experienced when he was interacting with Ms. Schabusiness. In another portion of his report, he notes, in any event, there was no evidence whatsoever of Ms. Schabusiness being distracted by any form of hallucinatory phenomenon. That's on page 15 of his report. I'm just summing some of the highlights that were also gleaned during the testimony. On page 16 of his report, he notes that Ms. Schabusiness indicated that she can assist her attorney in her defense by giving him all the information possible. Thus, she offered that it is important to be forthcoming with defense counsel. So he's able to help me. He can't if I don't be honest. Indeed, she stated that she has been honest with Attorney Freilich about the circumstances of this case. The report goes on in another location to indicate, quote, when considered in that light, there simply is no reasonable basis on which to conclude that Ms. Schabusiness lacks capacity to behave appropriately and communicate rationally, given that she has now twice clearly displayed such capacities. He goes on to indicate, quote, she has no difficulty grasping the roles of relevant courtroom personnel and the adversarial nature of the criminal proceedings. Again, I found all of those to be very insightful and credible. They seemed very credible. I've weighed the credibility of each of the experts regarding this topic of competency, and I find those observations to be credible from Dr. Seipel. I've observed Ms. Schabusiness interacting with her attorney. Obviously, I can't hear what they're talking about, but as I sit up here, I can see everything that goes on in the courtroom. I can see them interacting, discussing. Ms. Schabusiness indicates she thinks she can work with him. She understands what the courtroom procedures and players are. There's been occasions of inappropriate behavior, which Dr. Seipel indicated on testimony here, that he was fundamentally unable to rule out that they are volitional in nature. Satisfied, based upon all the evidence I've received, that the greater weight of the credible evidence in this case, and my assessment of the credibility is included in that the greater weight of the credible evidence supports a finding that Ms. Schabusiness is competent to proceed to trial, and I'm going to make that finding now. So that's the decision of the court. Then regarding the competency hearing, that piece of this case is now concluded for today. The jury selection is scheduled to begin at 1 o'clock. I believe the jury was requested to report at 12:30, so they should be ready to go when all of us are sitting at council table at 1 o'clock up in branch 1.